Back to the application process. Understand that an application can take several months to process. You may be examined by a Social Security doctor. The first decision is made by your state agency, New York, New Jersey, Connecticut, wherever you live. And if you're denied, you have to file a request for hearing within 60 days of a denial. If that's denied, you get an administrative appeal to the Appeals Council. Again, you must file it within 60 days. And again, if that's denied, federal court review. And some cases actually go to the Circuit Court of Appeals, but generally on a novel question of law, not on a factual question. So each step is 60 days from a denial. Okay? Why is it important to try and win on the application? I started to talk about this earlier. Number one, it's not true that all applications are denied. What is true is that most claimants are unrepresented at that level, and claims are usually not well documented, or the claimants don't complete the forms properly, or say dumb things on the form. The other thing is, many people in my profession are unwilling to get involved, but a well-prepared and properly timed application will get you benefits earlier, avoid the ancillary issues that affect credibility I talked about, result in lower attorney's fees, avoid the unduly long wait to get a hearing, which in some boroughs is over 2 years, avoid having continually redevelop your claim and get up-to-date medical evidence, and even if you do lose, you'll have a strong record to obtain what we call an OTR, on-the-record decision, at the next level if you have to go to hearing level. They have such a backlog that they try to take the obvious cases and pay them without dragging you in for a hearing, and that short-circuits some of the time, okay? If an attorney tells you they won't work up your application, that's probably not the attorney you want. Don't accept comeback when you've been denied unless your case falls under the compassionate allowance cases, okay? Those cases, we just feel you just simply don't need us, okay? The attorney should be able to identify if it's a compassionate allowance and at least write a letter on your behalf to get that case to the top of the pile, okay? What happens at a hearing? It's conducted by an administrative law judge. Your testimony is under oath, recorded electronically. Parties, a lot of people at a hearing assistant, an interpreter if you don't speak English, your attorney, witnesses on your behalf, could be lay witnesses, could be a doctor, and MA and VE, what's that? Medical advisor and vocational expert. I'll talk about that in a second. Medical reports are accepted into evidence. The doctor need not appear, although sometimes we do call them when the record has a lot of items in dispute in it. We may need a doctor to explain why it's all over the place and explain the disability. The judge frequently will call expert witnesses, could be one or more medical advisors. What is their proper role? Are the symptoms consistent with the findings to explain why that is? Give an opinion on functional capacity. They do that, they're not supposed to, okay? They've never examined you. If your own doctor has trouble doing that, how the hell can somebody who's never examined you give an opinion on the functional capacity? Yet they're asked to do that. This is appropriate for a medical advisor. Does a condition meet or equal a listing? Whether treatment can restore ability to work if there's a question of you not following prescribed treatment. To assist the judge in understanding complex medical terms. Assist the judge in understanding the impact of multiple impairments. Medical advisor's job is supposed to explain the medical evidence. Unfortunately, they're too frequently used to deny claims, okay? Vocational expert. Their sole role is to identify whether your past work was skilled or not, and identify the skills you had in the past work. Identify jobs you could transfer such skills to in response to hypothetical questions posed by a judge or an attorney, okay? So they're supposed to basically say if there are jobs that use those skills. If you're found that you could do sedentary work and you're under 50 and you have a skilled job, are the skills transferable and to what? Okay, and set forth the number of such jobs. But again, a lot of them are not used that way. A lot of them, some of the judges will simply say, can this guy work? Okay, particularly when claimants are unrepresented. And if that's not challenged, usually they'll say, oh yeah, they can work and they can do all this stuff. That's an improper response. They're not there to testify if you could work, okay? Judge has great discretion. They can grant or deny benefits or amend your onset date or find only a closed period. They can also reopen a prior decision. They can reopen a prior decision within 12 months of a second application. Where does that happen? Somebody applies, they lose, they give up, they're going to try and work, doesn't work out, they file another application, okay? Judge can reopen that first application. Can also reopen an application made within 4 years for good cause show, maybe new evidence, okay? Wasn't available at first. The guy lost because he couldn't get this evidence. It was a hospital record from out of state, whatever. Now they come in with the new evidence. A judge can reopen a decision up to 4 years old. It's a lot of retroactive money there, okay? Judge can also send the case back to the state agency to reconsider the evidence if he thinks that they did a slipshod job, okay? The ALJ can adopt findings of fact and conclusions of law that we draft on your behalf, okay? And they can issue favorable on the record decisions. How much time we got? Okay? Once you get a decision, the auxiliary claims are processed, the award certificate is issued, direct deposits, or you get a check. If it's unfavorable, you do your appeal. Your attorney should write a memo of law on your behalf. Appeals can take 1 to 3 years. Appeals counsel, like the judge, can reverse and award benefits. They rarely do that. Remands for a new hearing, they do that a lot, or affirm the denial. If they affirm the denial, you go to federal court. Okay, now, I mentioned quarters of coverage. I don't have the time to get into this intricate stuff. My partner said I made too many slides. My partner was right. But I'm just going to click through these and just to give you an idea of some of the other issues that do apply. Quarters of coverage, what does it take to get a quarter of coverage, and what the maximum amount of income you pay Social Security on. Different rates, it goes up every year. Trial work period, we talked about. If you're on benefits and you go to work, if you make above this amount in 2008, you're using a month of your trial work period. If you make below it, you're not even using a month of your trial work period. It won't be counted against you. Okay, so any income above $670 a month, you use a month of the trial work period, you get to work for 9 months and still get your full benefits. You gotta let them know. Got to know you're doing it. After 9 months, the benefits are suspended, and you have a re-entitlement period of up to 36 months, where you just say, hey, didn't work out, and go back on benefits, okay? SSI amounts. Right now, those of you who would be getting SSI, the maximum is $761 for a person living alone, $697 for a person living with others, and it varies depending upon your living arrangements. It's income-based, okay? A lot of people always ask me that, so I drew the slide in. Okay, that's prior years, goes up every year. What do? I kind of alluded to that. I'll just run through them quickly. We marshal evidence, we file your application at the right time, we complete your forms, we secure functional capacity evaluations, vocational evaluations, develop a theory of the claim, make sure all the evidence is there, we prepare you to testify at the hearing, we stay on top of the doctors, we point out the salient laws and regulations to the doctors, we'll advise you, we obtain vocational evaluations when need be, we identify additional impairments and say you better go see a doctor about that. We cross-examine medical advisors and vocational experts at a hearing, make statements, write briefs, and file suit where necessary, okay? How do lawyers get paid? Can you afford a lawyer?